Hello. It's time, yeah? Hi, everybody. It looks like it's about time for the panel to get started, so if you could please take your seats. Thank you all very much for joining us on our panel, where we hope to find some kind of data détente and explore some of the challenges, but also the opportunities that present themselves in transatlantic data sharing. Now, as some of you may know, there's been a lot of changes legally coming out of Europe in the past year that are potentially going to present some disruptions and certainly change some things about the $260 billion in digital services trade that currently cross the Atlantic. So my name is Molly Schwartz. I'm an associate policy fellow at the R Street Institute, and I'm also one of a team of researchers working on a project called My Data out of the Helsinki Institute for Information Technology. And there we're actually working on an initiative to restructure how people manage their personal data systems, looking at user-managed access protocols and some new consent receipt technology. So I have a very vested interest in looking at not only just wringing our hands about the inherent tensions between US and EU privacy laws, but potentially seeing how we can come to some kind of consensus and make data sharing work in a way that more directly responds to the wishes of us, the data subjects. And we're lucky to have a panel today with individuals and representatives of organizations who have been working on these legal changes and operating within this framework. So we're really looking forward to hearing from them today as well. So I'm going to open with a question to Joe McNamee, the Executive Director of EDRI. And so what I would like to ask you is the general data protection regulations were agreed upon last December, and this is a strengthening on the General Data Protection Directive. So what are changes that we've seen from the directive to the regulation, and what can we expect to see in this next 2-year implementation phase?
On a very broad level, the first very geeky point is an important one, and that is that the legal form of the instrument has changed. So in 1995, we had the directive was launched. And the directive is basically a guideline for the member states for what they should do. And each member state then goes away and does it. So when the European Commission came to look at updating the framework, they looked at what was happening in the EU. They saw 28 different countries with 28 different laws that were more or less based on guidelines that they'd received quite a long time ago. And we were actually completely in line with industry at that stage, saying this is too chaotic. We need to have one rule, one set of rules for Europe. And in Europe, one set of rules is called a regulation and not a directive. So the first big change was going from a set of guidelines from a directive to a law that was going to be equally applicable. Now, because it's a specific law and not a set of guidelines, it needed to be an awful lot more specific. And therefore, the new regulation is an awful lot bigger, an awful lot longer. There are a lot more words, which scares a lot of people because it sounds like more legislation, but it's actually just doing the work on a European level that was previously done at the national level. So not an awful lot changes, or a lot less changes than the huge lobby from industry seemed to think was changing. There are clarifications on issues like consent, on issues like enforcement. The level of fines, which scares the living hell out of industry, has been set at up to quite a high level. But to actually hit that level would be very, very, very difficult. There are a small number of new elements, one of which is data breach notification, which is something that is not news on this side of the Atlantic. And then we have additional elements which are more of guidance than of obligation. So the notion of privacy by design, that when you're developing a service, that the privacy, the protection of the data that you're collecting is built into the design of the product, rather than designing a product and then going, okay, how do we respect the data that we've collected needlessly in this process? And similarly, data protection by default, the notion that when you launch a service or when the person signs up to the service, you start from a level of protection that's the highest available in that technology, and then the individual can work back from that if they so wish. So that's 200 pages of regulation in the shortest amount of time that I think I can manage. I can give you a 1-week seminar sometime if anyone's interested.
Thanks. So now I think we're going to move on to talking a little bit more about Safe Harbor and the Privacy Shield. And we have sitting here Max Schrems, who is an Austrian legal student who quite famously brought Facebook to the European Court of Justice in October, which then ruled that U.S. privacy and data protection laws are not adequate. They are not essentially equivalent to European data protection laws, and they declared Safe Harbor to be invalid. Now, there are over 4,700 companies relying on this Safe Harbor protection, and within the 15 years that it was implemented, only 4 complaints were launched to the Federal Trade Commission in the U.S. So, Max, what do you see as being not working under Safe Harbor? Why did you feel it necessary to bring it to court?
There are so many reasons. Basically, Safe Harbor was a system where, as a U.S. company, you could self-certify so-called Safe Harbor principles that were miles away from European data protection law. Basically, there are 2 things that are regulated. One is sharing the data with a third party and change of purpose. Anything else you could do more or less unregulated. There was like duties to inform, duties to give you access, but everything else was basically unregulated. And even these 2 things you could easily circumvent by 2 sentences in the privacy policy. So there was effectively no protection in the private sector, which was, from a business perspective, also interesting because it was an issue of unfair market situation. Because U.S. companies could be on a European market without any regulation compared to any Chinese, Indian, Russian company that is on a European market that has to follow all these laws, and could thereby get away with it. So that was the interesting thing on the commercial side. On the government side, it was interesting because Safe Harbor said there is an exception for national security, and whenever there is any conflicting U.S. law, this would override a self-certification, which is obvious because you can hardly self-certify your way out of the NSA rules or laws. And that was the key reason we brought it down this time around, because there's a bunch of new case law coming out of the European Union on mass surveillance. We had the data retention case in Europe that said that just retaining the data for, like the metadata of your phone calls for 6 months to 2 years was a violation of your fundamental rights. And we basically just walked up and said, what the NSA is doing is 10 times as bad, so this must be 10 times as much invalid, which the court saw the same way. It was a very simple argument. A big problem we have in Europe is that the European Union laws do not apply to member states. So we have member states doing more or less the same thing. It's not all the member states, but it's certain member states, which is an issue as well. So that's the reason I oftentimes pushed that this judgment was also a judgment generally on mass surveillance, not just on the U.S. It will be relevant in Europe as well. They're just legal challenges. So basically the problem we have in Europe is it's like in the U.S. until the 1920s. Back then, the Bill of Rights did only apply to the federal government, not to the states. And that's kind of the situation we have right now in the European Union on national security issues. The European Commission now has come up with what they call a privacy shield, which is basically the same text as Safe Harbor, a little bit updated, so it's a little nicer, but the fundamental flaws are just the same. The principles, they're now called privacy shield principles instead of Safe Harbor principles, but they're basically the same. And they have the same, shortcomings. And the whole question of mass surveillance is also not really dealt with. So there's obviously no real change in U.S. law. They've basically just taken the same thing and passed it again. So I see generally that the industry is right now advised by lawyers to use alternative methods. There are standard contractual clauses. There are other things that you can use to transfer data from the European Union to the U.S. I don't think the privacy shield is going to be a solution that's stable, and that's a big problem that the industry has pushed a lot to come up with some solution, but it's not a stable solution. It's going to withhold a court test, and I think everybody's expecting Privacy Shield to go right back to Luxembourg and be struck down again in the way it is right now, which is very unfortunate because we could have really come up with a solution of this issue. But the pressure was so strong to just get something done that we didn't really get anything done in the end.
And if I can add one more thing to that, I think it's important to put that lots of talks about trust in these negotiations. And as a data subject, but I would like to use the term individual instead of that, I don't have much trust in the European Union after the Turkey deal ever in a human rights case. I mean, I know it's not directly linked to the Privacy Shield, but I think it's an important point what Max made, that it's not only about the U.S. that we have to talk about.
Thanks, Fanny. And this is Fanny Hedvegi, the International Privacy Fellow at EPIC. And I would actually like to direct my next question to you. So as mentioned, there's been this Privacy Shield text that has been passed, and instead of providing a blanket agreement like Safe Harbor did, where data could just be transferred to the U.S., companies, I think, have to certify as agreeing to the Privacy Shield. But some people have seen certain issues. So can you tell me a little bit about the role that data protection authorities will play? Because I know Max has referred to the Privacy Shield as putting lipstick on a pig. And I know one of the primary concerns were about the lack of changes in terms of, in case of national security and bulk data collection. But there were also some issues, I think, with the roles that the data protection authorities play. So Fanny, if you could talk a little bit about that.
Yes, there are many issues related to that question on both sides of the Atlantic, I think. And EPIC has been advocating for an independent privacy agency to be established in the US, and that didn't happen. But if we talk about the data protection authorities, their first role is going to be about the adoption. Let's not forget that this Privacy Shield has not been adopted yet, and there are still many points of intervention for civil society and other actors. And the Article 29 Working Party will deliver its opinion in mid-April, which consists of the DPAs. So I think that's the first role we have to emphasize. And as far as I believe, some criticism is expected to come out. And under the framework, it's not completely clear. We know that there will be a power to suspend data flows, and what discussions we had with Commissioner Jourova, the European Union is quite willing to suspend data flows after the adoption, which is a little bit hard to believe, because this Privacy Shield should not be adopted in the first place, and we shouldn't talk about how to suspend it. What the US NGOs believe the EU should have done and still could do is to request the US to end the 702 surveillance as a starting point. And yeah, we can go into more details later.
Sure. I do have one question. President Obama signed the Judicial Redress Act into law, which grants EU citizens the right to enforce data protection rights in the US. How do we feel about this?
Oh, we feel that it actually does not grant European citizens to have meaningful judicial redress. It's just, that's also a lipstick on the pig. The Judicial Redress Act, from the beginning, was a very, very narrow possibility. In the, even for US citizens, the US Privacy Act doesn't provide much, and it provides even less for Europeans. And in the very last
doctrine that we have. So if you, for example, have a Swiss person whose data is going to Europe and then to the US, you just need the Swiss person to go up to court and the whole thing is falling apart again because he's not covered. And so these are all these flaws in these negotiations where they just try to get something done and you just need to go have a Swiss person go up and it all falls apart again. So that's really, you wonder if they are not thinking that or if they're not even, you know, going that far, or if they just think it's not going to come up and we got a solution for a couple of years. And
I just realized I've been remiss in my role as a moderator. I was supposed to inform you that you can type questions in at slido.com #RightsCon, and we are in the hub. And I will be sure to address these questions if you type them there and they get upvoted. And also at the end, we'll have a Q&A session when hopefully we'll also be able to take some questions from the audience. Now I'd like to move on to Ken Carter, who's here from Cloudflare, and ask a little bit about how, given the changes in the data protection regulations, the invalidation of the Safe Harbor Agreement, and now this tentative privacy shield, how are U.S. companies that are potentially handling European citizen data dealing with what's going on? What avenues are you taking at Cloudflare?
Thank you. This has actually thrown a whole monkey wrench into our business. Dave, I see, is one of my associate attorneys. He's sitting here in the front row. Dave now spends a significant portion of his time discussing with our customers, our business customers, retail customers, and our enterprise customers, what should we do? And the answer is, we don't know. And it comes out that the customer doesn't know either. So we are now groping in the dark, trying to figure out how we can have a mechanism for the lawful transfer of personally identifiable information for our EU customers. And quite frankly, we don't have all that much. We have an email address, phone number, things of that nature, for which we need to run the service, to bill the customer, to create a customer account. Other than that, we actually don't have much personally identifiable information. So this creates a disproportionate problem for us. I wish I had a solution. I wish I had a really clever to take their most intimate details and post them online. This point was driven home to me yesterday when I was talking to a U.S. congressman who referred to those people as porn stars, right? And at the other end of the continuum, we have someone like Howard Hughes, who is a recluse, doesn't talk to people, doesn't answer the phone, and we need to build a system that handles everything in the middle. So I'd like to turn this around to some of the other panelists and ask Franny and ask Max. We're going to be back here in 2 years. You've already made an objection to Privacy Shield. Quite frankly, I don't think we're there yet to make a determination whether we like it or not. You have already expressed an opinion. Let's short circuit that. How can we figure out what is the appropriate privacy mechanism to create lawful transfers of data outside the EU to the US that gives us and our customers certainty?
Yeah, it's an interesting question. I think we got to separate two levels. The one part is kind of what companies can do with the data. That's a rather easy solution. We have the standard contractual clauses in these cases that are very complicated, that the administrative burden of it is big. However, we could take these principles and put them into a new framework that is multilateral, where you don't have to have a contract with each individual company. Typical example, what I proposed to Europe, like the Justice Commissioner, was to say we have standard contractual terms that you can just copy-paste in your own terms and thereby be adequate. We could do the same thing with principles like safe harbor principles and just update them to the same level as the European Union. That would, of course, mean that U.S. businesses would have to, limit your data usage. It really depends on which kind of business you are. If you're just hosting data, typically don't care about it too much. If you're Facebook, you care very much about what you can do with the data or not. So in the private sector, I think it's not a big problem to find a solution. However, even that was not possible. The U.S. was so reluctant to move that they didn't even get any changes in the private sector where there is no conflicting U.S. law. So that was something that was hugely frustrating, that they didn't even get that done. In the government sector, it's much harder, and that's also the problem with the standard contractual clauses, because whenever you have conflicting national law that allows mass surveillance, you're just in a situation where Europe has these fundamental rights. We're not going to be able to change them. It's just like changing the Bill of Rights in the U.S. is not going to be something that's possible overnight. And the U.S. is just not moving on any of the national surveillance issues. And that's a deadlock that I can solve, that no one of us can solve, basically. I think that's where the big issue is coming out. And I don't have a solution on it either. I could only escalate it.
But I'm afraid we're conflating two things here in our privacy discussion. I think we're starting to unpack that you have bulk surveillance, bulk collection at the government level. I don't know any U.S. company who's not a provider to the NSA who supports that, right? Then you have commercial collection, commercial use. We've all seen creepy ads that track us around the internet. That's not so cool. But into that wart, we throw just about everything else. And we can at least start by separating out commercial use from national collection.
Yeah,
Right?
that's what I'm trying to do right now.
One of the first things that I did when I came to Cloudflare is I made governmental requests an express part of our privacy policy. It had previously been implicit, but I unpacked it with a sentence or two that said, we will treat governmental requests as a privacy violation if they're not subject to due process of law. I don't know what else I can do to strengthen that.
That's the deadlock. Like if you're subject to U.S. law, you basically got to follow that, and that conflicts with European Union law. And that's something that can only be solved on a political level. I'm, basically as a law student bringing up a case like that, you can only escalate it to a level where you have to solve it. They obviously didn't. And this is going to ping pong back. It's just a fundamental clash of European human rights and fundamental rights doctrines, where there's a body of case law that they're not going to change overnight because the U.S. is trying to do mass surveillance. And the U.S. is basically saying we're not moving on it. And that's the deadlock. That's just the part where I don't see a solution. I'm absolutely with you. In the private sector, we got to separate that totally. In the private sector, there are solutions that are possible. However, it was interesting that even that didn't work. So I'm rather frustrated from the outcome.
But when you say that it's quite obvious that none of these companies are in favor of the mass surveillance practices, I would really love to see as much lobby for ending 702 surveillance, as much lobby we've seen in the US for many cases, but the Privacy Shield as well. So as I said, we are talking about the end of 702 surveillance, and the sunset clause is coming up. So I would love to ask for every company to join NGOs in this battle, and let's do this.
Happy to. It's a headwind to our business.
And it was interesting because that was the idea of the whole case. The problem we had in Europe is that we had the Snowden situation, and we knew that our politicians are going to send angry letters to the U.S., and that's basically going to be put in a big, trash can, and that's it. Escalating the problem through the businesses, basically, that are interested in being on the European market, you actually had some leverage and some interest on the U.S. side to get that problem dealt with. And that is the point where we got it. The solution is just not coming up. That was originally the plan because that's the only path you possibly have as a European to ever get anything done.
Take control of your panel.
Oh, sure. I mean, you guys can keep going. But actually, Ken, I do have another question for you. Obviously, an issue that we're seeing here is tension between two different sets of laws. Laws are applied locally. Digital services easily cross national borders. Are you seeing any push in customer demand for data localization? So if, for example, there's a U.S. company that U.S. laws would apply to it if it stores its data of a European citizen in the U.S., that people then want that data stored in Europe, and what will that do to your business model?
Yeah, that's a great question. Let me rewind the tape a little bit and explain what Cloudflare is for people who might not know us. Cloudflare has built a network called a reverse proxy, and that's just a fancy way of saying a bunch of computers that sit in front of another computer and do stuff for that computer. And the kinds of stuff that we do for the computer, the origin computer, is we handle all the inbound requests to that. And we look at the request, we determine whether that's just Fred surfing the internet, and we improve the page load performance of the website, or we determine that that's just an Estonian bot and to block it. And we do this, we have about 76 data centers in 39 countries. So we're doing this all over the world, and one of the benefits is that now that we're all over the world, we are physically closer to our customers' customers. So the page loads better, we can mitigate attacks locally, not globally, so the benefit is our not localizing data. In fact, data localization is the opposite of what most of our customers are paying us to do. Now, we have increasingly been asked by our customers, not by governments, but by our customers, to create localized products. And that's actually, there's actually engineering work that's going on at the company to allow customers to have the flexibility to toggle things on. I only want to return requests from your data centers in fill in the blank, in the EU, in Asia. And that will make performance worse for the customer. But if it's what the customer wants and the customer understands that this is not as good as the global solution, I'm happy to provide that at customer request. So this gets to be more of a commercial problem. I think that the the policy discussion of data localization encourages our customers to say, oh, we have to be data localized, when in an engineering standpoint, they probably don't want to be.
Thanks. We actually have a couple of questions here for Max, which I will go ahead and pose. The first is, what specific aspects of the Privacy Shield would you amend or add or omit to make it more stable?
Basically, in the commercial sector, it would be the easiest thing. You could more or less copy-paste what we have in the standard contractual clauses, put that as principles, and you would at least, in general, get a big solution for the commercial sector. That's like very kind of rough idea, but basically, I like roughly painted, but that's basically the path you could take. The other thing is we have a problem with oversight in the U.S. You can go to a external arbitration service, which typically doesn't really lead you anywhere. You can then go to your national DPA in Europe. They can refer the question to the FTC, but the FTC already said they're not going to investigate all of these complaints. That's also on the initial, 4 complaints that they got. They got many more. They just all go to a big database, and the FTC is just not investigating them. So that's the oversight issue. You could possibly get a solution as we have it for human resource data, where U.S. companies can self-certify to deal with one of the European data protection authorities to be kind of the mechanism where you can bring your case. The big issue is, again, the government surveillance, and that would need really legislative change in the U.S., or at least executive orders that would, limit it to a level that would be acceptable on the EU law. And that's the point we're not really seeing. I got to say, however, that to kind of also take a step back, you have 2 types of third countries on the European Union law. You have countries that have more or less exactly the same level of data protection as we do, which is only a handful of countries. That's about 10 countries in the world, and if you take away the microstates in Europe, you basically have 5 countries worldwide that fall under this realm. And so it's not a thing that all these other trade partners we have would be in this first bucket. The US wants to be in this first bucket, and there is a huge interest from Europe as well because it's a main trading partner. But all the other countries in the world are going after a second system, which is Article 26. Where you have contractual regulations, where you have exceptions in the law where data can be transferred, but it's not a free flow of data to these countries. So the big question is the US on a level that's close enough to Europe to have a totally free flow of data? Or is it in the second bucket, which is all the other countries in the world, where there are certain sets of rules you have to comply with or not? The big problem in the second set is really, again, that even under standard contractual clauses, if there's conflict in national laws, you're not allowed to use them. So it's really this big issue is conflicting national laws, and that's an issue we have.
Yeah, thank you. So now I'm going to pose on my own questions, and I will get to some of the other ones that are up here on the screen. So I think a big goal with both the data protection regulation and with the Privacy Shield is that it would be easier for individuals to redress their concerns that their data is not being adequately protected. And I'm going to open this up to anybody on the panel. In your viewpoint, does it seem like with the new legislation in place, or that will potentially be in place, that there actually is easier individual redress? And let's say I am an individual who takes issue with how some company or government has been handling my data. What do I do now?
Company or government? That makes it into 3 questions. In principle, yes. One of the problems that we've been trying to solve over the past 4.5 years of discussion of the new framework has been making the rights real. Because we have some countries that have quite weak data protection authorities, my home country, Ireland, being one of them, and coincidentally also the home of Google, Facebook, Microsoft, LinkedIn, and Twitter, but I'm sure that's just a coincidence, and the UK and 1 or 2 others. And they also have more or less strict implementations of the 1995 directive. So you have quite a difficult, unpredictable path in front of you as an individual in Europe at the moment, because it depends on how good your data protection authority is. It depends on how what enforcement measures they can use. Depends on the implementation of the directive. The intention of the new legislation is to strengthen all of the data protection authorities across the board, give them all meaningful enforcement powers, give them all sanctions that will actually make the companies sit up and take notice. That's the plan. The vote is expected either this month or next month. There will then be a 2-year implementation period. Unfortunately, industry has become a little bit schizophrenic over the past 4 or 5 years. At the beginning of the process, the Commission organized a high-level roundtable and asked industry and civil society, what do you want? And industry said, we want a harmonized, predictable system across the EU. Please give us that. We'll even put up with, one of the big companies said, we'll even put up with stricter rules as long as they're consistent rules. The European Commission said, thank you, we know what we have to do. They launched the regulation, and then the mother of all lobbying campaigns started, and every possible interest group said, we want an exception for this, we want an exception for that. And now there are more exceptions, national exceptions, built into the regulation as a result of industry lobbying than there were articles in the existing directive. So how these flexibilities are going to be used are implemented in the next 2 years will be a determining factor in how much this will have the outcome of giving people a clear, predictable set of rights that they can then get enforced. There's a whole other answer for the government part, but I'll leave that for the next question.
We'll touch back on surveillance at some point. So now I'm actually going to go up to one of these questions, which is similar to one of mine, which is, despite some exceptions, will the General Data Protection Regulations stifle competition and consumer choice in the EU by smaller, likely more innovative companies, given its heavy burdens? And this was actually something that I wanted to ask about, which is that there have been people arguing on each side, if there's insufficient privacy or data protection, what are the benefits of going with government regulations to ensure this versus having private companies innovate and offer privacy as a competitive advantage? And so that's a question that I would actually like to toss to Ken to start out with, that how do you see it working, offering privacy as a competitive advantage as opposed to having it ensured by legislation?
Yeah, we have always viewed our privacy policy being very restrictive. It fetters some of the things that we want to do in business, but we understand that because we're in a trust-based business, and this gives us an edge over our competitors. We've always seen our privacy policy as a competitive advantage. To the regulatory question you asked, I gotta say I'm not an expert in privacy. The one area in law that I would say that I'm an expert on is the U.S. Part 15 rules. And if you don't know what the Part 15 rules are, they are the Federal Communications Commission's rules that enable unlicensed device operations. So your Wi-Fi, your Bluetooth are all permitted by these rules. And the rules are brilliant. And the reason why they're brilliant is they specify certain standards at the bottom and at the top. How much energy can you emit into the ether before you create an unacceptable probability of radio interference to other devices? And they're really engineering driven, and they're unfortunately very complex on it. But the beauty is that they don't tell you what to do, they don't tell you how to do, they just create minimum maximum thresholds. And I think any effective privacy regulation would ensure a minimum floor, but not necessarily a cap, so that innovators can get in without having to run the gauntlet of onerous privacy restrictions. You're not dictating what privacy practices should be across various different companies and industries where the data practices and the data held may be extremely different, and you're allowing people to innovate. I'm treating your data better than the other guy come buy my product. So to the extent that you could specify those as sort of minimum requirements and maximum requirements and let people do appropriate things in between, you've got yourself a set of Part 15 rules. I think it would be great.
Annie, would you like to jump in?
Yeah, I'd like to add something to privacy as a unique selling point. And David Martin, our colleague at the LIBE hearing, provided some insight about what users want on both sides of the Atlantic. And both groups want higher standards for privacy. And it's not only about innovation, but we are familiar with companies like Bahnhof, for example, in Sweden. And it's not only about the commercial side, but to push back on government requests. And we haven't talked about what the users can do, because obviously I believe that companies and governments should be accountable and should respect privacy as a human right. But users are in position to protect their privacy, and I'd like to recommend privacy-enhancing technologies. And please check out my tech demo about the right to hide. It's a new website about privacy-enhancing technologies by the Hungarian Civil Liberties Union. And maybe this is a good point to mention that individuals will be in a really hard position in their own countries when they come up with new legislation to ban encryption and all these fun ideas, and centralizing surveillance. The Hungarian government just earlier this week came up with the idea to tear down the wall between law enforcement and national security data collection and data use. So when you talk about UK and France, please mention Hungary too.
Okay. Joe, do you have any thoughts about whether GDPR will stifle competition and consumer choice?
I was thinking particularly of the small business angle. I think the simple answer is no. There are cases when you can give companies a lot of flexibility, and that they will have a selfish interest in heading towards the protective side of their options. So, for example, on spam, they need to protect their own systems. They need to ensure that their customers are happy and not overwhelmed by spam. So they can be trusted more on that issue. If you're a small business and you're going to somebody and asking them to trust you, if you ask them to trust you, hello, you've never heard of me, but please trust me with your data, you're going to be in a weakly regulated market, you're going to be at a disadvantage compared with a name that you've heard of. So getting into that is more difficult. If you've got a standard where there is clear, strong data protection, and you say, hello, I'm a business you've never heard of, please trust me, and your potential customers know that there's a framework that means that you're not just trusting them, you're trusting a predictable and enforceable network, then you're more likely to trust the small business. So far from being a disadvantage for small businesses, particularly because the regulation also has various carve-outs in places where there is a risk to small businesses, the companies are actually better off in a structured environment like that.
Can I just quickly add something to that? I think the biggest problem and the biggest lie we have in the whole privacy debate is this notice and consent and user choice thing. It's not working because it's way too complex for an average consumer. It does work in the B2B business possibly because you have people that understand what you're doing. But the average consumer is not going to have any idea about what's going on these devices. And I think it's absurd how we try to argue that an average consumer should get informed, make an informed choice. They come home after 10 hours of work and just want to download an app to buy something. They're not going to read any of these stuff. And this idea of self-regulation of this is going to work by the industry is just not working in an environment that is, first of all, hugely complex. Secondly, you typically have monopolies where you don't really have a choice. I mean, I can choose to have my data going through Apple or Google. I mean, what kind of choice is that? So I don't think that this is going to be a solution. So the approach to regulate stuff to at least have a common set of rules on the market where then people can compete does make, at least in the European context, much more sense. And I think the interesting thing is going to be the penalties also. It's up to 4%, which is totally different to today. Like in my home country in Austria, it's 25,000 euro. That's the maximum penalty right now. So a lawyer is telling me my fee is more expensive than just paying the fine, and that's going to change. And I hope that this is fundamentally changing how also companies from other countries are operating, because the regulation is based on a market principle. So the idea is not it applies to companies that are headquartered in Europe or situated in Europe, but anyone that operates on the European market falls under the regulation. Enforcement is another question then. But typically, if you have stuff in Europe, there is the possibility to do enforcement then as well. So I think that's going to be kind of an interesting thing.
Yeah, thanks. So now I'm going to turn to this question on surveillance. This is a question posed to Max, but anybody feel free to jump in. The U.S. response is that they should not look up to the EU because the EU doesn't the same, if not more, mass surveillance. What's your response to that?
It's absolutely right. As I said previously, we have a jurisdictional issue. That's something that's heavily ignored in the U.S. The European Union has a jurisdiction over commercial data usage, in this case transferred to third countries. It does not have jurisdiction over national security, which is resting with the member states. If you have countries like the UK that doesn't have a written constitution, you have a massive problem there. But even in Germany, they, for example, say that if you're a third country resident, like I'm in Austria, you're not protected under German law. So there is a huge issue here. There are cases coming up in these countries. They're going to Strasbourg. There's another court in Europe that's responsible for these things. The court has decided in 2 cases right now against Russia and Hungary in exactly the same direction. So I think we see movement there as well. But it's in the end a jurisdictional problem. That's the reason I tried to push in the PR and the media of the case to say this is a mass surveillance case. It's not an anti-US case or a US mass surveillance case, which of course never works because it's a EU-US issue, and then this whole thing comes out and dominates the scene. But that's absolutely right. We have a lot of issues there as well. The problem with the argument is also that you can hardly say that I'm, as an Austrian citizen, where we don't have mass surveillance like this, have to put up with what the US is doing because the UK does something strange. So it's kind of this argument of, someone else walks across the red light as well, so why should I pay the fine? And this is just not how law works. I mean, it's a political argument, it's interesting, it's important, but it's legally irrelevant.
I agree with Max, but also I think this is a quite comfortable position for the European Union to take. So the jurisdictional problem actually exists, but member states are really happy to invoke national security as a caveat. So I think there is a room to do deeper research and investigations in that, because as government use national security as a exemption from anything, it's the same in the EU member state relations.
Right. So now there's another question, again, returning back to the idea of what are the new regulations going to provide a barrier to entry for smaller or newer companies that are looking to open but find the potential costs too large to get started? So the question is, what if the costs of complying with the framework are so high as to prevent a small company from ever existing in the first place? So I feel like what's interesting is we keep coming back on this question that we should have some kind of floor, some kind of baseline that's somewhat harmonized, that companies can rely on, that provide a certain amount of privacy, but how to make that floor not so high as to make it too difficult for new businesses to start that don't potentially have money for a large legal team and things like that.
The biggest problem is have clear laws. Like I'm coming from a small company background as well. I'm from my family. What you want to have is a clear law that you can follow, that you can read, that you understand. And that was the biggest problem we had with lobbying in the whole data protection reform, is that we now have concept like risk-based approach. We have a paragraph saying, according to the risk of your company, you have to do the following things or not have to do it. If you didn't choose wisely, you got to pay 4% of your worldwide revenue. That's not a law you want to have, and that was really something where the industry lobby was doing stuff that was absolutely anti-business in the hope of watering it down, but pretty much just creating legal uncertainty. On the other hand, what you got to say is there's privacy law, and it covers almost everything you can do with data, like data protection reform. But what an average business does with data falls right through the law. It's all legal. You're covered by the law. but it's not restricting what you're doing. You may have to give access to the data that you're holding, but the burden is actually rather limited. And it was interesting as well that the lobbying was mainly on what you can do with data because it was coming from the big industry. It was not about, for example, documentation duties, information duties, which is an issue for small companies. And that was something that was very interesting to me, is that the lobbying was oftentimes said it's for SMEs and we're trying to protect them. But the interest that were pushed was pretty much what the big companies are got to do. They don't care for documentation. They have someone that does it. They care on what they can do with the data. And that was something that where the industry has just not done a good job on lobbying, I think, in the end. And that's a problem with the GDPR.
Yes.
So building off of that, something else that's come up in the GDPR as it stands is this concept of data portability. And this is something else that kind of goes back and forth, where some people say the stiffer data portability regulations you have will make it more difficult for companies to comply. And others say that the more that data is allowed to flow from one service to another, this will make it easier for new businesses that are data reliant to start up. I'm going to open this again to the panel. What are your thoughts on data portability and having it subject to regulations?
I just want to get a little bit of clarity. Is what do we mean by data portability? Does that mean I'm on Facebook, I don't like it anymore, I can click export and go to Path or to Friendster and have all my pictures come? Or does that mean that when companies exchange their customers' data, there's a standard format and this is an ongoing? So maybe we get a little clarity about what we mean. The first, this was a problem I worked on at Google, and that there's just there are two problems here. One, you actually kind of want to have that, but the wrong people want to have that, and the people who want to have that are the people who are at scale, right? So that it's very easy to switch to my network, and you don't want to come, and I've got other things other than the portability that lock you in, and that's just size. So, and the other thing is these companies, you know, Friendster and Facebook, they're all largely the same sort of product. But when you get into other products that aren't the same, then how do you legislate that sort of portability? You get into sort of lock-in and scale problems that you actually don't want to regulate. You want to constrain the behavior of larger players such that they don't create de facto standards, and now everybody's got a right to their standard, and you lock out other players. And we saw this 2 decades ago in sort of the browser wars, and there used to be a word processing program called WordPerfect that sort of got locked out because Microsoft became the standard. And WordPerfect you were not capable of transporting your documents back and forth between WordPerfect and Microsoft Word. And it sort of becomes the tool of monopoly behavior. And so we have to be really, really careful here.
Any other thoughts on data portability?
I'm trying to the regulation is so long, I can't actually remember what was decided, so I'm cheating here. But it was watered down a lot in the process. So it's not nearly as onerous as it was originally proposed, but I can't remember. Don't tell anyone.
No problem.
And there are a lot of limitations. Basically, if there's a common format, if there's an open format, that's oftentimes left to further regulation. And so that's going to be interesting how it's implemented in practice. And obviously, there is no common format for exchanging Facebook data. And that's going to be interesting how that is going to be implemented. And I see data portability was meant to be a kind of market opener in a way, because you just have these big platforms that lock in the data. It's going to be interesting how it's implemented. I typically call it more a right to access in a proper format instead of getting pieces of paper and PDF files or something like that. So it's at least an improvement there, and possibly it can help in certain situations, but it's going to be a big issue how to implement it, just like you said.
Yeah, and as mentioned, data portability has many facets. Some of it is if, for example, you wanted to get your own personal data back from a company that was holding it, do you get it in the form of stacks of PDF papers, or do you get it in some kind of machine-readable format? Or it also gets into questions of intellectual property and copyright. if you buy an ebook from one service, will you then be able to own that and read it on a different kind of device?
Casper Bowden asked for his data from Microsoft, and he received it in boxes of paper. But if I can give a good example, I was very impressed several years ago by Yahoo. They changed their service to be much more privacy intrusive, their email service, and they said it was remarkably clear and simple. They sent an email to their subscribers that said, "This is what we're doing. We imagine that some people won't like this, so we've done a deal with a competitor that doesn't do what we're planning to do, and you can stay with us if you want, and if you don't want, we will lift everything that's yours and put it on our competitor service, and you can continue using all of your data on this other service if you so wish." I then subsequently heard lobbyists in Brussels talking about data portability, explaining why such things were completely impossible and could never happen and it was too complicated. But Yahoo showed that it could be done. They showed remarkable flexibility for their customers, and it's remarkable what innovation can do when a company cares enough.
And to be fair, there are a lot of companies that have responded to requests for data portability. So I know Google now offers Google Takeout and different services. I would like to get to another question from the crowd, and this is directed to Ken. Shouldn't the private sector push for an international standard for protecting customer data so that it reduces compliance costs? Now it's between the US and the EU, but what about other countries? And I think this gets further to things that we've brought up previously, which is that we need some kind of common standards that people don't need to be operating on a country-by-country basis.
Yeah, I think we've largely answered this question, that we want some sort of standards but not hard and fast rules, and we want to harmonize on those globally. Let me put a little bit more information that we haven't discussed into the answer, and that's like if you see things in addition to privacy rules like MLATs and DMCA takedowns, that they're starting to standardize on some of the best, and they become first through treaty, then through practice, a set of rules that everybody follows, and it will follow the internet in terms of, the internet is basically a rough consensus and running code, and I think if we can get to that point, we will be in a very good space. Why do we want that? Well, the internet allows everyone to operate at scale very efficiently. Even little players can achieve scale very quickly, right? So if you've got a country or a set of countries or region that doesn't participate in these best practices, that doesn't achieve this consensus and running code, they will cut themselves off from the rest of the internet. Now that's bad for all participants, but it's particularly bad for the people in those countries because they are not getting the benefit of a search engine or a social network or any other service, email service that they might want to use at global scale. So the answer is yes, we want to get to, I think, a rough consensus in running code.
When we talk about human rights and the question of other countries came up, we must mention trade agreements and the ongoing negotiations and how they deteriorate human rights. And obviously, Edward Snowden did a great favor for us, but we still haven't found the chlorinated chicken of privacy that actually brings people to the streets. And I think this is one of our tasks as civil society to find that. And we can see in TTIP and TPP these cybersecurity caveats, for example, that allows countries to introduce bills about undermining encryption. And this is a process that we must stop. And the privacy shield is also part of this discussion. And actually, the funny part is, for me, I saw this question about the sun. And I think it's very interesting because I've heard Jan Albrecht talking about the sunset clause for Privacy Shield. And the Privacy Shield won't meet any of the criteria of EU law, not only about the judgment, but I think it's not either the GDPR. And I haven't heard the negotiators talking about reviewing this agreement based on the GDPR. The purpose limitation, for example, in Privacy Shield, which is so vague, it will fail for sure.
I see exactly the same problem whenever you ask about Privacy Shield being compliant with GDPR. The answer is we haven't debated that with the US, which is absurd. I mean, the thing is coming up in 2 years. And that's the problem. I mean, and that's what business is saying behind scenes on Privacy Shield, is that they say, you know, it's nice that there's a new treaty, but we're not going to be able to rely on it because it has all these flaws. Another thing on international standards, there is by the Council of Europe, so not a European Union institution, but a broader thing, Convention 108, which should exactly do that. It's open to any country in the world to have, you know, baseline standards for privacy protection. And interestingly, they're written in a tech-neutral way, so stuff like when data is not needed anymore, it has to be deleted. So it's a kind of very tech-neutral approach of it, as European data protection law is. And that has spread around in other countries as well. The big country that is sitting on the table of these negotiations but never participating is the US in the end. But that has become internationally to a certain kind of standard that you see in other countries as well, and you see these principles being adopted. And interestingly, a lot of these principles actually come out of the US historically, but like from the 70s or something.
Thanks. So now I do want to ask kind of one more question that I would like each of you to answer, and then I'll open it to the audience if any of you have questions. What would you say is one thing that you can point to that makes you optimistic that despite the disruptions in the past year, the changes that have happened will lead to further innovations around privacy than we have seen in the past? And this can either be something that's in the legal field, in the tech field, anything. And
I'll go back to my earlier answer, is that we all want to participate in this network together because participation is beneficial to all network participants. And so everyone here has an interest in sorting this out. We may disagree on the specifics or on any particular point, but we know that we all want to interconnect and to participate in the internet.
I have to think if I want to be optimistic, but I can point to two separate issues. One is that we already mentioned that I'm very happy to learn that industry is behind us to end mass surveillance in the US. That's great news. And also from a bigger perspective, I'm very optimistic because people want to have more privacy. And if they want more privacy, it will trigger companies to engage in those kind of innovations.
As the lawyer, I would say the 4% are pretty much the one thing that makes me optimistic. I think we see now that this data protection reform, Europe is in the end the biggest market in the world, and any company that wants to operate on a worldwide basis will have to look at that. And we see that starting now. They know they have 2 years to comply with it. So far, they were like subject to the law, but there was hardly any enforcement. And this big stick could possibly be the turning point for a lot of companies to revisit that issue, to say, okay, we really have to do something here now. We don't want to be in compliant in 2 years and then explain to our shareholders why we pay 4% of our worldwide revenue to the European Union. And that is kind of the point that makes me the most optimistic, which is not probably a positive spin, but something that could at least work in the end.
Anybody who knows me knows that's a bad question to ask me. I think if we can get this failure turned around fairly quickly, I think there might actually be a meaningful negotiation. What's happened after the regulation was adopted in 1995, the directive was adopted in 1995, a solution had to be found with the US. The US refused to negotiate meaningfully. We ended up with Safe Harbor, which was it wasn't credible. I worked in industry at the time. Nobody believed it was going to work, but it would keep the wolf from the door for a while. In 2002, the European Commission had to produce a review, and they could see that it wasn't credible, and it was delayed by something like a year in order to rewrite the facts, in order to pretend that it was working. Then there were academic studies that showed it wasn't working, and everyone just sort of kept their heads down. Let's pretend it's working. Then the Snowden revelations came out, and the Commission produced its communication on rebuilding trust. They spent 2 years talking about negotiating. Then we had finally the court decision confirming what everybody knew since 1998. And then the Americans said, okay, let's talk, but not negotiate. The new US ambassador to the EU very graciously invited me to a dinner with the negotiators. I don't quite know why. But Thursday before the Monday that Privacy Shield was announced, there was nothing even resembling an agreement. So from Thursday to Monday, that whole sham was thought up by somebody very imaginative. And there was no negotiation. If this is turned around quickly, then finally there will have to be a degree of personal political responsibility for the people that in the European side that failed miserably and completely and abjectly and humiliatingly in this process. And then maybe we can have a negotiation and an agreement that suits us and suits industry and moves us forward finally. There you go, some optimism.
Thanks. So now I'm going to open it to the audience. Are there any questions? You can take your time and ponder. I will throw in my own dash of optimism. So I do believe that there are a lot of people who are taking privacy and kind of individual control over their own data quite seriously and see it as a viable business model. There is actually a company based here in California called ForgeRock that's been working on something called user-managed access protocols that was essentially let people consolidate and have more control over the levels of consent that they give different parties to use their data. And I would say there are a lot of initiatives coming, some from the research sector, some from private sector companies in Europe, and most notably in Europe and in Australia and in New Zealand, but all around the world. And so I would say that even as some of the legislative pieces of this have been somewhat dicey, there hasn't always been consensus, I would say that it has at least lit the fire under innovators and people in the private sector that see this as having some kind of consumer demand, and there are people who are looking to respond to it, if that's a nice optimistic note. So, is there another? Max, yes. The GDPR, are these
Vague,
questions?
unclear, complicated, not simple, likely to be a barrier, blah, blah, blah. Yes. and that's what... I'm sorry. But that's basically what the big issue is. And the interesting part is that mainly came out of industry. That's like the craziest thing about the GDPR is that this vague wording is, I mean, I read all the amendments, 4,000 to the law, and we looked at where they were coming from, and it was called a project, it was called Lobby Plug, to kind of look where the lobby papers resemble the amendments and stuff like that. And exactly these points were the things that were coming out of industry, and I think that's going to be a problem for the industry for a long while, because as a privacy lawyer, you love that stuff, but because you just got to go to the right judge, and they're going to decide your way if it's vague, and you can pretty much do what you want to do. And that's unfortunate, but it's something that you cannot blame on the European Union. You cannot really blame on the privacy people. You can mainly blame that on the lobbying that happened, and a couple of mainly the Conservative Party in the European Union pushing that, and that was really an interesting thing how they basically shot in their own foot. And
Sorry, they shot the SMEs in the foot. The big companies led. I mean, I don't think that general regulation is terrible for SMEs, but a lot of the complexity comes from big companies tabling amendments, coming up with clever strategies to make things more complicated. But it's more complicated in a way that they can cope with, that small companies can't cope with. And the lobbying of the small business organizations in the EU was not good.
Now, just to push back a little bit, I know that Epic was writing to try to get the Privacy Shield negotiations to be more transparent because, as we've heard, they were happening mainly behind closed doors. And while I would say that there are a lot of us up here who are in favor of more transparent trade negotiations, wouldn't that be an argument against having things be more transparent if, as things are more open, there are going to be other interested parties trying to get in there and make changes? What would you
Oh, yeah, they are represented already. What Epic did is we filed freedom of information requests because the EU and the US announced Privacy Shield on February 2 without revealing the text. So we filed a request, and as Joe mentioned, that there wasn't really something that was an agreement. When actually the US Department of Commerce replied to our FOIA request that no such agreement exists. And a few days after, the agreement came about. And in that interesting coincidence, I find it a little bit unfortunate that the US, one of the US's lead negotiators, Julie Brill, quit the FTC like maybe 2 weeks after the Privacy Shield and ended up in a huge law firm. And so I think the industry has already there, and they can express their interest quite well.
Okay. Well, thanks, everybody. I think we're going to go ahead and wrap it up. Thank you for coming.
Joyful end note.